I think most people hear words like blockchain, crypto, tokenization, AI, and tend to switch off. And I get it, because for too long this stuff has been explained badly. Too much jargon, too much hype, and in my opinion, not enough clarity. I'm Oliver. I've spent over a decade working inside financial services, fintech, and digital assets, and I've generally had the privilege to work with some of the most forward-thinking firms in this space. But throughout this time, one thing has always stood out to me, and that is the general lack of awareness in wider society of the genuinely transformative impact of these technologies and how they will affect most, if not all of us, throughout our lifetime. There is so much more to it than just Bitcoin and making speculative crypto investments. So I started this channel to make this knowledge accessible. I think for too long this information has been difficult to access and reserved only for those in certain roles and companies. What I want to do is to cut through the noise and give you the intelligence and information that actually matters, as best I can in plain English. So, let's get into it. In this episode, I want to outline an interesting conversation that I recently had at a blockchain conference, because there are a number of people, particularly those actually who worked in law firms, who didn't know at first what I'm going to tell you today. Smart contracts. Self-executing pieces of computer code that live on a blockchain. They automatically carry out the terms of an agreement. They're already legally enforceable under English law. Now, although the idea of a smart contract actually goes kind of way back to the early 90s, it is not really until the creation of blockchain that their use became widespread. I think from memory it was the launch of Ethereum around 2014, 2015 when they really gained traction. I certainly know that when I studied my own law degree back in 2011, and I probably show my age here, but they absolutely were not a concept that was discussed. There's no new legislation required for smart contracts, no special framework needed. The Law Commission of England and Wales reviewed that question and concluded existing common law can accommodate smart contracts really without any statutory reform. So what that means right now is a smart contract executed on a blockchain can create legally binding obligations under English law, the same law that governs really every commercial contract in the UK. And yet, plenty of lawyers, business owners and professionals in the UK have no idea this is the case. So today I want to explain what smart contracts actually are, what the Law Commission, what their finding actually means, and why this really matters to anyone who works with contracts, agreements or transactions of any kind. Let me give you the clearest possible explanation of what a smart contract actually is. So think about a vending machine. You put in the right amount of money, you press the button, the machine will give you the product if it works. But if it does, you don't need a person standing behind it to verify your payment and decide whether to release a snack. The conditions are met, so the action happens automatically. A smart contract, I think, works in a similar way. So it's a piece of code that says if the condition is met, then execute the action. When that condition is satisfied, the contract executes automatically. You don't need a human to check it, no intermediary, it just runs, right? So the difference from a traditional contract is this. A traditional contract says what should happen. A smart contract makes it happen automatically and transparently without anyone being able to interfere once it is deployed. And here's the key point. Under English law, that automatic execution can create a legally binding obligation. The Law Commission confirmed it. Let me be precise about what the Law Commission actually concluded, because the devil's in the detail. The Law Commission reviewed smart contracts as part of its broader work on digital assets and technology law. Its conclusion was clear. English law is sufficiently flexible and technology neutral to accommodate smart contracts. No new legislation is required for them to be legally enforceable. Now, what this means in practice is that a smart contract can satisfy the requirements for a legally binding contract under English law. Offer, acceptance, consideration, intention to create legal relations, all of these can be present in a smart contract. Now, the Commission did identify some edge cases, deeds for example. They have specific formal requirements that smart contracts cannot currently satisfy. And questions of private international law, which country's law governs a smart contracts, remain complex. But for the vast majority of ordinary domestic commercial contracts, supply agreements, service contracts, licensing deals, payment arrangements, smart contracts are already legally enforceable under English law. This isn't a future possibility, it's the current legal position. Let me give you a couple of examples of smart contracts already operating in the UK and European contexts. Supply chain payments, I think, is the biggest one. So smart contracts that automatically release payment to suppliers when goods are confirmed as delivered and verified. You move away from 30, 60, 90-day payment terms, and there's no disputes about whether conditions were met. The contract executes when the conditions are satisfied. Property as well. Smart contracts being used in tokenized property transactions to automatically transfer ownership when payment is confirmed. I talked about the land registry pilot actually in another video. It demonstrated exactly this. I encourage you to go and watch. Quick pause. If you're finding this useful, please hit subscribe. Every week I cover exactly this kind of shift in plain English. It really helps the channel grow. Back to it. Now, if you're a lawyer, I'm sure the question you're wondering is this. Does this mean contracts do not need lawyers anymore? No, and here's why. Smart contracts are really good, I think, at executing clear, unambiguous conditions. If payment is received, transfer ownership. If goods are delivered, release funds. If temperature exceeds a certain threshold, trigger an alert. But commercial reality is really that simple. Contracts involve negotiation, interpretation, and ambiguity in judgment. What happens when the goods are delivered but damaged? What happens when the payment is received but disputed? What happens when circumstances change and the parties need to renegotiate? Smart contracts can't handle that ambiguity. They execute based on computer code. If the real world does not match the conditions exactly, as it rarely does, they don't really know what to do. That is where lawyers remain essential. I think though what changes for lawyers is not whether they are needed, it's what they're needed for. The mechanical, process-driven parts of contract work, the verification, the condition checking, the execution, those are being automated. But the judgment, the negotiation, the interpretation, importantly the dispute resolution, that remains very real human work. The lawyers who will thrive are the ones who understand how smart contracts work, but specifically what they can and can't do, and how to advise clients who are using them. That's not a new skill set, and right now not many UK lawyers have it. For business owners, the opportunity is significant, I think. Smart contracts can dramatically reduce the cost and time of routine commercial agreements. Anywhere where you have a repeatable process with clear conditions, there is probably a smart contract application. Now, look, the honest version. Smart contracts really cannot handle ambiguity. They cannot fix bad code. If the contract itself is written incorrectly, it will execute incorrectly. And because it is on a blockchain, you often cannot reverse it. There have been significant losses in the crypto space from smart contract errors. And that's why auditing the smart contract code matters enormously. While English law accommodates smart contracts, not every jurisdiction does. Now, if your contract involves parties in multiple countries, the legal position in each jurisdiction needs to be considered carefully. None of that means smart contracts are not valuable. They absolutely are. It means just like any powerful tool, you need to understand both what they do well and where their limits are. I hope you've enjoyed this video today. This is not legal advice. I would encourage you to speak with a properly qualified lawyer where you have questions about the application, interpretation, and the use of smart contracts, and whether you're considering that for payment processes, business operations, etc. Look, this stuff is moving fast, and the gap between the people who understand it and the people who don't is only getting wider every day. That's why I'm here, and that's why this channel exists. If you found this episode useful, then please hit the like button. It takes 2 seconds and it helps more people find exactly the type of content we've been discussing today. Now, if you want to keep up with what's happening more broadly, then please subscribe. Every week I put out content that discusses exactly the kind of shifts that we've been talking about today. If you want to go deeper than YouTube allows, then please head over to our website, linked in the description below. You can book a bespoke coaching session directly and over time access structured training materials. No hard sell, no spam, just the right conversation and the right information at the right time. I'm Oliver and this is Read Between the Blocks. I'll see you next week.